Is there a motion we go back into session, please? All in favor, please say aye.
Aye.
So moved. Next item on the agenda today is under Community Business, item C. This is the second reading of the post-construction stormwater ordinance. I'd like to call on Magistrate Eldridge.
Thank you, Judge. We have before us today ordinance number 16-830-348. That will be repealing ordinance 06-830-361. This went before the Utilities Committee. We've looked at it. There are a couple of things I believe you're aware of that we are wanting to change. In regard to those, I'll let you take care of that, but we will make a motion that this be brought forward at this time. Second.
Okay, moved and seconded that this ordinance be brought forward. And before we begin discussion, I'd like to make a motion that a couple of words be changed here. And then if everyone agrees, we can discuss it further from that point. The first thing had to do with on page 5, there was the prior wording said the ordinance shall apply to any new or redevelopment of land disturbances over 1 acre or more. And we've added here, and for projects that disturb less than 1 acre, if they are part of a larger common plan of development that disturbs 1 acre or more. So that clarifies that a little bit and addresses a, let's say, a concern that was forwarded to us by the Division of Water. Another recommendation I would like to make, and that in the next paragraph, it says here, the last sentence says, this would include, but may not be limited to, any proposed major subdivisions and commercial developments. I'd like to recommend that we just change that to, this would include all subdivisions and commercial development. That sentence is sort of a backward negative sentence there. Addresses everything by saying it would be include all subdivisions and commercial development. On page 6, under section 4, review of stormwater management, there's an ambiguous word here in sentence 2. It says acceptance indicates that minimum requirements or intent are met and does not imply a guarantee of performance. I'd like to recommend that we eliminate the word or intent. It's too ambiguous. It can't be actually determined what someone's intent is or is not, and like to suggest that we get rid of those two words. And then I don't want to complicate the matter any further. Before I go on to another correction in the paragraph, is there any objection so far to what I've recommended?
I have a question.
Yes. Hang on a second, please.
If you already have a motion on the floor, are you actually now making a second motion without voting on the first?
I'm making a motion to amend the, we had a recommendation to be accepted. I'm making a motion that we amend the recommendation to include these changes.
Second.
But, okay, wasn't quite finished yet, but that's okay. The bench should die.
Yeah, on that same sentence, where you just took out the word intent,
Or intent.
where now it says the minimum requirements are met and does not imply a guarantee of performance. Well, what that means to me is, well, it's, we design it with the minimum requirements, but we don't guarantee it's going to work. I thought the whole idea of this thing, the stormwater management plan, was to protect people in these various incremental time frames of a flood.
Well,
That's like saying I'm going to buy a car, I'm going to give you a warranty, but I'm not going to guarantee the car is going to work.
correct me if I'm wrong, or the way I'm reading that sentence is that the county engineer will review the plan and possibly accept it, but the county engineer does not county does not guarantee that this plan is going to work in perpetuity.
So then I'm to assume that anything that, according to the county engineer, in their estimation, if they don't work, then they wouldn't approve it, correct?
Correct, but they are not infallible.
But that's not what this says.
Well, that's why it says it doesn't guarantee that it's going to work.
It doesn't say anything about a guaranteed rejection.
Okay. I'll let county engineer address it.
Okay. So has the judge said, yes, I'm not infallible, or whoever my who may come after me, but I also want you to understand that when these plans are presented, they're stamped by a professional engineer who is saying with their professional engineering license it will work. Therefore, the idea if something on the plan is a failure, then it goes back to their professional engineer's license. I'm looking at it without running all the calculations again and so forth to see in theory if it seems acceptable.
Okay, so basically you're checking their work.
I'm checking their work, and they're guaranteeing it with their PE stamp.
And if their work somehow or another didn't work out right, they designed it, you checked it, you approved it, but then it didn't work, and then they got the professional engineer stamp on it, and you go back on this engineer. What if this engineer is no longer in business? What if it's 10 years down the road? It's obvious that it was poor design. Because, another engineer may come in and say, they should have never done it this way. They
Well,
were infallible.
it kind of goes back to the, if you want 10 different opinions, ask 10 different engineers, kind of saying,
So basically, if it doesn't work, somebody's going to have to fork up the money to fix it. And it's not going to fall back on any particular engineer.
It's going to fall back on the engineer who stamped it and/or his firm if the firm is still in business. I don't know how it works if the firm's all folded. It's kind of like bankruptcy, I suppose.
Well, I'm not real happy with, I'd rather have the county engineer looking at something saying, yes, this will work to the best of our knowledge.
Well, then I'd have to design everything.
Well, you know, but you can say this won't work and you can reject
Well,
it,
sure,
correct?
I say that all the time, and I reject plans because I don't believe they will work.
Then I think you need to put something in there about the guaranteed performance, or it will be rejected. That's all I'm asking for, Judge. I'm trying to give us an out.
So that gives us-
Well, I think I feel we're on high ground there, and we're not saying we guarantee that it works. Other people are supposed to have put their professional license to it. There is a certain amount of human subjectivity in here that happens everywhere. I think when we go out and approve a building permit or do an electrical inspection, but if that fails at some point in the future, you can't say, well, the county inspected this. The county's responsible for it. I mean, we do the best, we give a good faith effort to do the best we can, and we expect everybody else to do the same, but there is no absolute guarantee that anything is going to hold up forever.
All right, so wait a minute, let me finish here on this point. So in other words, if that's the way we're going to go with it, then we need some kind of guarantee that whatever this plan consists of, we need to have some sort of guarantee that whatever that they're doing, be it a topographical elevations for drainage or the concrete ditches, the culverts, the pipes, the head walls, whatever it is, how are we guaranteed that those are put in actuality? Are they put in the right place? Are they consistent with the plan calls for? Were they installed properly? Where's our guarantee there? Does that go back on is this engineer going to guarantee that all this work was put in properly?
Yes, he does. They currently do. They currently submit a certification of completion saying that everything was put in correctly per their plan.
Now, I believe that, at least while I'm county judge, this is a new day, and we're going to exercise a, let's say, much more aggressive checking system than maybe we've had in the past. I don't know how things have gotten to where they are. We have a lot of good things in the county, and we all know some things didn't work. But I don't think anybody purposely started off saying they weren't going to work. We're just going to do it anyway. Maybe somebody did, but for the most part, we have to, this is a new day. We have to, apply strict adherence and strict construction to the interpretation of things, and the county engineer will be responsible for what is put in, not just accepting somebody's word that it's correct.
You're talking about actual inspections, on-site inspections.
Yes, sir. Right. We have to. We can't afford to take any additional steps in the future or be forced to take steps that were not rigorously examined to begin with. So I think we do accept in a lot of things the professional opinion of outside individuals, but nevertheless, we have to, still doesn't totally exonerate us from doing our best to make sure that we agree with what those opinions are.
Well, I think all the magistrates up there, I can't speak for all of us, but it seems like in my district, my number one complaints is drainage, and it usually goes back to a poor design and poor installation.
I think somebody over here did, somebody?
I did.
As Likens?
Thank you. I'm pretty familiar with this because I stamped these erosion control plans myself. But we are only, to answer one thing, our statute of limitations is only 1 year or 2 years on this. So it does take someone who's in charge to look and make sure that this has been designed according to minimally accepted standards of what's been done before. But I think what they're saying here that we can't guarantee his performance is this is designed on like a 10-year flood and check for the 100. If we have a 500-year rainfall event, it's going to fail. And that's what we're saying in here, that if it's put in, we can't guarantee that it'll never fail, but we can guarantee that the right size pipe is being put in, that what she's saying is that an engineer goes back after these erosion control plans are finished, and we will check the invert elevations and things like that, and we as an engineer will say that 24-inch pipe was used, and we check off that the installations are done correctly after the project is finished.
Measure Sparks.
Yeah, Beth, I want to kind of get away from the details of the contract here, and I want to kind of understand in the real world how this is going to work.
Okay.
So let's take my district, for example. I've got Confederate Cemetery up here, and all that rainwater floods down into Confederate Estates, which floods down into Ashbrook subdivision and onto Ash Avenue, which is a state road.
Right.
When we have all those people that live in there are paying their fees, but that subdivision's been there for 30-something years, maybe longer. How are these people going to get served by our new board here when the Confederate Cemetery, I mean, that's, who owns that, right? Who's control that? Who's paying fees on that? And of course, there's a 30-year-old subdivision here. Are we going to go in and rebuild all the sewers and drains of that subdivision? And the state road, are we going to come in and fix the drains that run in the yards along the state road? Tell me how that's going to work.
This ordinance that we're looking at today is just from anything that comes before planning and zoning forward. So, and I understand what you're saying, that your older subdivisions, they didn't plan for this. What they did was probably inadequate.
But they pay for it still
But I
every
understand
day.
that, and I think I'm going to refer to the judge to let him explain what if he would like to state something about where you see that program going for our older drainage issues.
Well, we're taking over the storm, water management program from the sewer district, and we have a 50-50 program to go out and help people who need help, and we have to look at each one of those and develop some guidelines as to how we're going to approach them. So, is that what you're referring to?
Yeah, we're still kind of in a planning phase.
Well,
We hope to be able to tackle some of this, but we're still in a very basic phase trying to figure out what we're, and how
see,
we're
that's
gonna
kind of my
take this
dilemma
program.
here. I'm not going to vote on something that I don't know what the end result is.
Well,
I need to know You know,
You're mixing apples and oranges there.
That's true. This is just one
This just
piece
has
of
to
the
do with
puzzle.
new subdivisions coming into the county.
okay,
It
but,
has nothing to do with anything that's already out there. That's,
but what I'm trying to say, Judge, is the people in my existing subdivisions are paying these fees, and it's only going to benefit the new subdivisions?
No.
no,
No, this is only one small piece of this whole stormwater puzzle. And what I think you're looking at is how we're going to address these older concerns, and that's a totally different piece than what we're looking at today. And
that has to do with the creation of the stormwater district. This is just a facet of our stormwater program. It's not the program. It's a plank in the floor of the program. It has to do with new subdivisions coming in, how they're going to be treated as they're constructed, when they present their plans for construction, what criteria they're going to have to go by and how they're going to be checked, and who's going to be held responsible in the future if something malfunctions.
So, will we see these other planks of this total plan in the near future? What's the timeline for complete rehabbing of our plan?
I'm not the decision maker on that, and I don't know if anyone would like to step forward with that,
Well,
but
we
we
just
will
passed,
hopefully
at the
soon.
last meeting, we passed the stormwater ordinance. We've created the stormwater board that's going to start on the 1st of September. Through the month of August, Veolia is still responsible for stormwater issues throughout the county. We try to handle some on our 50/50 program. We're going to handle more in the future after we get our new plan set up. Some money will be used for day-to-day and longer-term maintenance. Other monies will go into a reserve fund to help solve any major problems that may arise in the future. So we're still trying to fill in the details of how that's going to work yet. But this is one part that has to do with new plans. And the stormwater program, the money that was collected for that is for the implementation and execution of the MS4 program. If you recall, it had to do with clean water was the genesis of the entire thing. Stormwater it's been expanded, let's say by a regulatory concession, to include the idea that stormwater impacts clean water, so we want to be able to manage the stormwater too. But when we started off, I think we really were just trying to have clean water, and that was what we were mandated to do. So our fee has been, we've kept it low as we could for everybody in the county, and many people still misunderstand what this is about, but we have a desire to get out and do more stormwater management on public property and help people that have individual issues that are reasonable through our 50/50 program.
So, for example, Holly Gibson Road, you know, we rebuilt that road and we curbed the sides and everything, and we actually took out some of the kind of natural guttering along the south side of that road, as you recall.
Right.
Is that the kind of thing that we can improve on with this 50/50 fund or with other funds?
Well, adding, I think we can debate whether or not changing that, adding the curbing and taking away the existing ditch line was an issue. There are issues with springs and the flatness of the road and so forth that we could debate. I mean, we could get into the details of why that project did not turn out maybe as good as I was hoping it would have. Maybe this is something we can address either through the road department or we can address through the stormwater. We just really haven't gotten to that point yet.
Well, the Holly Gibson was not for the 50/50 program.
No, that was done under,
50/50
in
is
our road right
strictly
away.
where there's a impact on an individual's property through some unforeseen circumstance that has arisen. And I can think of one subdivision where a person bought on the lower end of a street. A number of new houses were built above that house over a period of time, and as the new houses were built, a lot of hardscape went in, and suddenly water's running off a lot of people's property down the street and down the hill over this person's property. And, you know, it wasn't anything that he did, and it really wasn't anything intentionally done by anyone else. It was just the cumulative impact of the expansion of the subdivision created a river through this guy's front and backyard.
Yeah,
And
and-
so we try to help alleviate a situation like that with a 50/50 program.
Okay, thanks, Judge.
Measure Greenwell.
Thank you, Judge. So am I assuming right that otherwise in the 50/50 program, we won't be going on to private property to remedy any situations with this money?
Well, we're talking about, again, you're talking about stormwater money that's being collected versus this ordinance here isn't really talking about any stormwater money.
Well, and that's,
Talking about controlling what other people build, and then who's responsible for it after it's built. If it would be, I think an issue that's in here somewhere is that if a new subdivision is built, an issue pops up, whose responsibility is it? Is it the developer, the homeowner, or the county, or the homeowner association? And that's something that I think we don't have a clear answer to. We're trying to hammer it out. And the 50/50 program was intended to help circumstances that were on private property that were created by, not created by that person or what they did, but just by the ongoing events of life here that were not controllable or foreseen, I guess is what you'd say. And not everything can be foreseen. We have, just have an unbelievable number of water issues in this county because of the topography. And the water
Lack of
water
maintenance.
shifted from one place, winds up somewhere else, and creates a new problem. So, does that answer kind of what you're
For now.
getting at there?
For now.
Okay.
If we change this document a whole lot, will we have to send it back to the state? Because didn't we have to send this for their approval?
No, we're not, the first thing I mentioned was a suggestion by the state, okay,
Right.
or.
But I mean, if we
you know,
change any more in
a
here,
pusher, you know,
will we have to send it back to them and have them approve
no,
what we
I
change?
don't think so.
I don't
We'll
think-
send them a copy of it, but the small changes we're making here are really just tightening the language. Measured Sparks.
Judge, on page 11, it's talking about enforcement post-construction. And it mentions,
Could we do this? We've got a motion and a second on the floor for the recommendations and changes I've made. Before we get into anything else, let's make a decision on
I can see-
those recommendations.
Those are your changes?
No, I actually have one more suggestion that I want to put out on paper just because it has enough change in it to, people need to read it rather than try to we can delete a word or two here, and that's easily enough followed, but you start when you get 8 or 10 words, it gets confusing.
Judge, would you be okay with us voting on what you've already discussed, getting that behind us, and then go with
Yes,
this other?
that's what I'm.
Is that okay with
That's
you?
what I'm trying to accomplish, right. Any further discussion on what we brought up there earlier? Okay, hearing none, all in favor, please say aye.
aye.
Opposed? Okay.
What do you vote, because there's a motion on the floor to adopt it, and there's a motion, and I didn't hear the second, to make the recommended changes from you, and there's 3 of them listed.
Yes,
But
and who
is there a
seconded it?
second?
Brad
Yeah.
Sparks seconded that, and we just voted on
So
that.
you just voted
Making those,
making those changes.
making those changes, right.
I'm sorry,
And I'll help you with them if you're confused about where we were on that. If this passed, voice vote, right. Okay.
Amendments have to be in writing.
Now, let me stick with mine here, and then we'll go to anyone that has something else. On the last page here, in the last paragraph or section 10 on page 11, it said whenever the county finds by inspection that a person has violated the prohibition, or there has been a failure, I thought it'd be just clearer if we say that when a violation has been determined to occur, and there's a failure to meet the requirements of the ordinance, then the county may order compliance by sending a written note of violation. Is that correction clear to, or suggestion clear to everyone here?
Yes.
In other words, I just changed person to violation and just made it a event rather than individual. And said it's, when something has occurred and there is a failure has been noticed, then obviously we're going to send a notice of violation to someone here. And that someone may be subject to more debate, but it's not part of my ordinance or my suggestion right now. And then down below, if there is a penalty assessed by the Code Enforcement Board, person has 30 days to pay. It says, here it says, the fee may be placed on the property tax bill. That is more clear than have it collected with any other taxes levied thereon, because this is not a tax, it's a fee. Okay? It's a fee, just like we have the stormwater fee on the property tax bill now, but it's not a tax, it's a fee. So I thought that the word fee should be there and get rid of the idea that this is some additional type of tax. It's not, it's a fee.
Judge, that's a violation though, so the regular fees they pay into stormwater is a fee, but the violation, I think that would be a different term than fee. Paying a penalty.
Well, well, that's an idea. I mean, that I could accept that as a change. We're trying to get this away from the word tax.
Yeah, I mean, it's a penalty may be placed on it. A fee is what you regularly pay, probably. That's semantics. That's old school teacher. I don't care either way. Does Stan disagree?
Would it be called a fine, maybe?
A fine may be placed on the property tax.
And would you have, it's,
It's a repair, it's the cost of repair, to mitigate the violation.
right, the cost of mitigation here, so it's really not, it's not a.
The cost.
All right, I'd make change that word fee to cost.
Okay.
About the cost,
To mitigate.
okay, we want to add those words, the cost to mitigate may be placed on the,
Mitigation cost.
You don't like this next comment.
cost to mitigate may be placed on the tax bill. Property tax bill, yeah.
Judge?
Yes, sir.
Okay, now, since we're at section 10, enforcement of post-construction,
Could,
am I to
could
make
we vote on these changes before
we
you?
might have one more here. Hold on a second.
Okay, well, I didn't know if you want to lump them all
These
together.
out.
No, this is in it, let's keep it, I'm working on this paragraph here.
Okay,
That's what I want.
We're going to make the assumption here that this enforcement action has to be occurring because someone has done something to the stormwater management infrastructure. In other words, whenever the developer leaves, and, okay, now, and we're going to make the assumption that it was all put in right and it all works real well. This violation here is not a violation on something that got left out. Poor Joe Blow buys a house and, whoop, there's a head wall missing. And we come out and say, hey, where's the head wall? Say, well, I don't know. I just bought the house. They're not going to be held responsible for that, right?
probably not.
Is it just basically where someone's going to be held responsible for fixing something that failed, not build original, right?
That's the intent, yes.
The intent. I
That is
like
what
that
it-
word.
No, there's a, everything is supposed to be in working order and there and complete when at the time that is turned over from the developer to the county. The idea is this is incorporating any lack of maintenance
Right.
related issues.
Okay, so that's the intent here. This is not to turn this into a construction deal. This is where if the maintenance has failed, something's failed along the way, you've got to fix it.
Yeah.
Someone's got to fix it.
Somebody's got to fix it.
Okay.
Measure Sparks.
That was exactly my question too. In the second sentence, it says, to meet a requirement of this ordinance or the maintenance agreement. Is there going to be an ongoing maintenance agreement with the homeowner or the homeowners association for certain sewers? Or once the construction is finished and it is turned over like a road to the county, and it's the county's problem to maintain it, right?
No, there will be a maintenance agreement. We have not finalized all of the elements of the maintenance agreement, but that will be an additional maintenance agreement coming forward between the county and the owner or its assessors that will detail that
So,
kind of things.
for example, I have a small drainage thing that goes through my backyard, it takes up half my backyard. Are you telling me that I, in perpetuity, have to go and maintain that? And I have to outlay costs to it, even though I'm paying my stormwater fees to maintain it? I have a maintenance agreement. We're going to have a maintenance agreement with every single house.
That's what the maintenance agreement says.
Good luck collecting all those fees. I mean, and if it happens and it's a whole street's worth of sewers.
You think everybody should pay for what's in your backyard?
Well, I mean, we do it on the roads.
Well,
If-
a road
if
is, a
it's
road is a
built-
different object than this. This
Well, I'm
is, this
saying-
is not, you know.
But I'm saying if there's a sewer or a culvert that runs through my backyard, are you saying that culvert's flows from all the neighbors up the road? Should I be the only one encumbered with paying for the repair of it? Just because it comes out at my spot in my house? Shouldn't all the people who impact that culvert pay for it?
I'm not so sure that, well, the alternative is who?
Well, the stormwater fee is there. You're charging people a fee once something is turned over to the county, unless that
Or is that
homeowner,
culvert in your backyard is county property?
there's a, what do you call it, a variant, what is it called, the
Yes,
Easement?
yes, it
Easement,
is,
thank
Judge.
you.
The easement does belong to the county because the county is the easement holder.
The county has an easement in my
He's
backyard.
an easement owner. There is. Yes,
So-
yes, it
Property owner.
does.
It really depends on what the record plat says. County's kind of, we have access to the easements. We do not take ownership responsibility. That lies with the underlying property owner.
That's correct. The property owner is the easement owner, the county or someone is the easement holder. There's a big difference there.
Right.
And the easement holder is responsible for the maintenance. What this ordinance is doing is moving the maintenance, your subdivision doesn't even apply to any of this. It's from this point on
Yeah.
that those people in those subdivisions will have to be responsible, either individually or collectively, for the maintenance of all the infrastructure when it fails.
That should be the way it is. It shouldn't be that the guy at the bottom of the hill gets everybody else's problems and now has a maintenance agreement where he's got to replace culverts and stuff like that because it happens to exit his property.
Measure Eldridge, does the utility committee have an opinion on this?
The situation, first off, let's get several things. This does not have anything to do with sewers. This is stormwater. Two, this does not affect existing subdivisions. What this would affect, using your example, if Confederate Estates wasn't there and there was a new Confederate Estates built, these regulations would make sure that the water coming off of Confederate Estates would not do the damage it's doing today. In other words, these are more stiff regulations going forward. In regard to the issue here, and we've been in meetings with Stan and Bobby Vincent, several engineers, but your issue you're looking at here as far as the stormwater facilities, somebody long-term has got to look over that. One of the things that Bob Dye, Magistrate Dye, and I have been talking about is the homeowners association. We've been back and forth on this. The judge has been back and forth on it. But in reality, it's just like the sewer district. We, as a county, do not feel like that the whole county should put funds into only those 6,000 people in the county that have sewers. Likewise, it was our feeling that you would not put the whole county's liability, for lack of a better term, into a new subdivision. In other words, just like Norton Commons has a homeowners association or other places have a homeowners association, they would have a responsibility for maintenance on their landscaping, lighting in the subdivision, and likewise on the easements that are drainage inside of the property. So if, using your scenario, this guy's at the bottom of 30 other homes, all of those drainages through the whole subdivision would be responsible for the homeowners. It would not be the one guy with the one culvert, as you said. The other side of this coin is, as Magistrate Dye and I have discussed back and forth, are homeowners associations capable of doing this? That's the $64,000 question. We know that there are homeowners associations that are very active and very enforceable. Norton Commons, again, for an example. You know, they have a myriad of things they're in charge of. My question is, if not them, then who? Are we going to, in the future, if a developer comes in and builds a new subdivision and there are drainage problems afterwards, are we going to take the rest of the whole county's funds to go fix that one subdivision, or are we going to make those people responsible for themselves? Be the same question with sewers. If the whole county is going to be responsible for that one subdivision, then the whole county should take into effect and be responsible for those 6,000 people in the county that have sewers. So, I mean, it's just, again, these are things, you know, and the judge and I have been back and forth on this. There's a million pieces to this stormwater puzzle. You know, in reality, we should have probably looked at all of these things over several years periods before stepping out on this. But to the judge's point, our hand has been forced a little bit through an NOV that came out of the DOW. So this particular document, we're under an NOV to get done with, and that's the reason that it's coming through so quickly. In regard to the other stormwater functions, there will be a lot more thinking and looking at how that's going. Magistrate Greenwell spoke a moment ago, and that's my concern as well. We don't want to use county funds on private properties without easements and issues that are going to get us in a bind going forward. So the things you're looking at, you know, these individual homeowners, that's going to be a long time in fixing because you would have to have easements on all that property. And trust me, from the project that I've been involved in, getting easements is not as easy as you might think. So I hope that'll help give you guys a little bit about where we're going to, and Ms. Fair.
All right, thank you. Magistrate Greenwell.
I guess I want to understand what the rush is. I understand we're under a notice of violation. Wouldn't the Division of Water be happier with a complete document that spells it out from A to Z rather than pass this ordinance and then figure out all the rules later on? I don't think it's in their heart that they would take us to the mat and kill us, you know, without having a good game plan. I just think we'd be better off to get this thing from beginning to end and present a complete document to the Division of Water instead of just doing this thing piecemeal. I really believe that.
And I don't know, I haven't spoken to Ms. Raines myself. This is the first time I've seen this, but this is the NOV that evidently was handed out. And we can take a minute to read that and see if it gives us a little clearer understanding.
What was the deadline on this is coming up? I believe it was,
We received it on the 19th. It's due on the 19th, which is what, Friday?
right. Now, we were, you know, under an enforcement order to have this finished by the 19th of this month. So my suggestion has been that I think we have a document here that we can go with. If it needs fine tuning in the future, let's step back and fine tune it. But my feeling is that we need to meet this, this deadline that has been imposed on us. You know, obviously, we think that people ought to be reasonable and give us a little more time to do this, but they're going to come back and say, well, you already had time, you're at the end of the rope.
Yes, so they've been talking to us about it since '09, and they mentioned it in March of last year that we needed to have this done in a timely manner, and then we got the Innovate says you absolutely must get this done now.
This, I don't see a due date on here, but I do see where it says 90 days within 90 days of receipt of this notice of this violation.
Yeah,
Now-
that's coming up.
Now, does that mean 90 days from this letter here, or 90 days of the date of the violation? Because if it's the date of the violation, we're way past 90 days.
Received on
No,
the
we're
19th.
talking about 90 days from May 19th.
And I have spoken to the
And
Division of
we-
Water, we're still good.
May 19th?
Right. And we
Judge.
did submit the first draft, or the earlier draft that we had of this stormwater ordinance to the state. They accepted it with the one
change.
clarification regarding less than an acre.
Judge, this does say that we can be fined $25,000 a day after 90 days. I don't know,
Fellas,
levy
I
that fine
just
on us,
don't
but
want to
they-
poke the bear on this.
But they
If we,
could.
let's do something, move forward. We don't have a single subdivision coming up here that's going to be affected by this that we can't make corrections on if there are additional thoughts that need to be put into it that can't be implemented before that happens. But I don't want to be a day late and a dollar short on this and get whacked.
Just a small clarification, Judge. You said this is originally from 2009 was the issue, right?
Originally from 2009, they had discussions with us that we needed to improve our post-construction ordinance. We had an audit with them in March of last year, and at that point, they said, you will be getting a notice of violation to get this post-construction ordinance done.
So my question is, between 2009 and March last year, what was the progress on taking this action? None? And who was Veolia working on it for us at the time, and they've stopped because we're not contracting with them anymore? Or, I mean,
Can't answer that.
this is just all of a sudden, boom, it's here, and we got to deal with it. It's since 2009.
It's far past the point of time to pin the tail on the donkey, so to speak. We have all been doing a lot of things since 2009. There's a lot of moving parts going on here all the time. Veolia has had the Stormwater District have had numerous conversations with the Division of Water. Things have progressed greatly. This is something that just kept getting pushed forward, and we're ready to do something here now. There's nothing wrong with what we have. I mean, it's a good document. I won't say that it couldn't have a few things changed in it that would be satisfactory to some magistrates, but overall, this was looked at by the state. It was approved. It's very close to what documents that other county fiscal courts have adopted. And so to sort of want to look in the rearview mirror and see what might happen at 10 years from now out in the future is not going to solve our problem for this week.
Mr. Carter?
May I, since I'm required to advise fiscal court, and we've got this notice of violation from the environmental cabinet, why, if they've approved our ordinance, are we making any changes besides the change they ask us to make? And if they've approved the document and we're looking at $25,000 violation charge, why are we even considering making any changes besides what they say needs to be changed? I mean, that's just, we can make changes anytime we want to, but why are we making changes that are different than what they say need to be made if they've approved the document? I mean, it's the first I've heard of that.
Well, I think the suggested changes were they're not major, they're minor, and they're all just fine tuning a piece of language here and there that they did not give us a suggested ordinance. They took what we sent and gave some feedback on it for one thing.
Well, I would,
But,
my advice to fiscal court would be to approve the document that the environmental cabinet approved with the one change that they said needed to be made. Suppose you send it back up there and they don't like the changes you just made. Then we're in violation. Perhaps.
Well, as you die.
I believe Mr. Carter has a good point, makes a very valid point. But he also said that you can change it later on. That's the part that I'm uncomfortable with. Now, if you and your staff are willing to forego any, as you say, any subdivisions that, we don't even have any subdivision supplies to, right?
Certainly not.
No, there's nothing
Well,
out
then-
there.
Then would it be fair to say that we're not going to accept any more subdivision plans until this fine tuning gets done?
I wouldn't say that.
Well, then.
That's impeding commerce and putting, what I think you're asking for is consideration of the determination of who will be the ultimate responsible party here.
No, I'm asking for a lot, there's a lot of things I don't like in this. We got to get the construction thing straightened out, like you said, put more teeth in it. We got to come up with who the ultimate party is. There's a lot of things in here that aren't, in my opinion, can be improved on vastly. But I just feel I don't get the comfort level. I don't feel the love about this.
Well, it'd be up to the court. I don't even know if the court would have the authority to prohibit the planning commission from approving any additional subdivisions. Although at this time, there aren't any that I'm aware of that have come up for consideration, are there?
There is nothing there are no new subdivisions on the August Planning Commission meeting, and there was nothing in TRC. So,
Measure Sparks.
Judge, could, if we were to pass this today with just the one change that they suggested, could we have a good faith promise from our staff that in the next 90 days or so, they'll work on the changes that we've talked about? And this is something that we won't just, kind of move on to other things?
I don't know that the staff needs to work on the changes. I think whoever wants changes needs to bring their own document before the fiscal court. Let's not shift the burden onto somebody else to do something.
Okay.
You want something different here, you show up with another document and we'll consider it.
No problem. I just wanted to make sure that at some point in the near future, we would have an agenda item to discuss this.
Well,
I wouldn't wanna
you
lump
get it
on
here
you.
and I'll put it on the agenda.
Thank you, Judge.
Judge,
I mean,
Yeah,
honestly,
I was just trying to
let's
demonstrate
not
that
shift
it's
it
not
back
gonna-
to the staff to come up with
Yeah.
what you think are the objections. You write the document the way you think it should be written,
I
and
just
then
wanted to-
we'll see if it goes anywhere.
I just wanted to make sure that everybody felt comfortable on the court, that this wasn't something that was just going to get forgot for the next 10 years.
Well, not if you don't let it get forgotten. I mean, we just can't shift the responsibility. We got to take it, each person who has a concern needs to take that on themselves and bring that concern forward, not expect staff to show up with something that you could either bless or not bless. We've come up with something here that we think passes muster, and it has. It's been to Frankfurt and back. They had no problem with it. And so if we tinker with it in the future to satisfy ourselves, that's okay with me. But if we don't have to go any further to satisfy the Division of Water right now. Magistrate Leslie.
Judge, we have an attorney. He gave us a piece of advice and has changed that one thing. Why don't we just change that one thing, go ahead and pass the document, and then if we want to change it in the future, we can do that. But this satisfies what the Department of Water wants done, Claudia Rains, or Abigail Rains, and go on. So that's what I think we should do.
Magistrate Greenwell.
Thank you, Judge. And this is a very minor item, but in looking at this notice of violation, I noticed it's addressed to Jim Morris. what is that all about? He hasn't been in county government for 8 years.
The only thing I can say is I have no idea who's on their mailing list or why. I mean, that was somebody that, Abigail Raines, who this letter came from, full well knows Beth Stuber's name. She knows my name, probably knows your name. So why she would put Jim Morris on there, she may not know, maybe doesn't know he doesn't work here anymore. I just can't, you'd have to ask her. I wouldn't have any idea how it's addressed to him. It did get to us, though. It had the right address, just, so. I'm not saying they're perfect over there by any means. I'm just saying they have the ability to, you know, create a problem for us that we don't need.
Judge, I have a question. We had counsel recommend his recommendation to us. I would love to make the motion, but I'm not chair of this committee. But I would look at Kevin Eldridge and ask him to make a recommendation at this point in time to move this thing forward.
Magistrate Eldridge.
I'd like to make a statement, and then I'll make that motion. Mr. Greenwell has hit the nail on the head there. We are dealing with a group that is not run the way that a business is run. You know, we've got a letter here that's addressed to a guy that hasn't been in county government in 10 years. Mrs. Stuber has brought up the fact that in 2009, we had a talk with this lady, and one of the things that she had a problem with was the construction ordinance. At that time, Mrs. Stuber was in charge of stormwater, and Stan was here, and also another gentleman that's no longer with us. We really couldn't figure out what was wrong with the ordinance. I spoke to the Division of Water and took our existing ordinances to Frankfurt. 2 weeks went by, I hadn't heard anything. Another 2 weeks went by. I finally called again, and I said, what about these ordinances? Give me a day, I'll call you back. 2 days later, I called them again, and I said, what do you think? She said, I think they look great. I said, well, those are the ordinances that you said weren't any good. She said, well, no, now that I look at them again, they're okay. So, I mean, this is the kind of thing we're dealing with. Yes, we've been dealing with this since 2009, but in 2009, they were suddenly okay, and now they're suddenly not okay again. So, I mean, in best defense and everybody else's, this is like nailing Jell-O to a tree. Now that I've said that, in abeyance with what our counsel says, I would make a motion that it be accepted with only the change that they suggested.
You got to withdraw the other motion first.
I will withdraw my first motion.
Judge, you made a motion to have it accepted, so that has to be withdrawn to have
Okay,
his done.
I'll withdraw my corrections that I proposed, but we've already passed those other three.
I have to withdraw them all.
And really, I can't see where Mr. Carter's opinion, you know, to the aside here, I can't see where any of those corrections actually impaired or changed this ordinance in any substantive way. They're just minor clarifications. We dropped the word, a very fuzzy word, intent. We just said people are going to comply with the minimum requirements. Not, why would we let them say, well, I intended to comply with it? Let's get that word out of there. I think what we had before is okay. I'll be glad to withdraw this motion here. And although, you know, they did pass it with us saying this was sort of referred to like a tax, and it's really not. But let's get, my initial objective today, as I mentioned to somebody, is to get something passed. Let's go back, come back later, we'll clean it up. Magistrate Sparks wants to clean up, bring it forward. I mean, you know, Magistrate
Don't put it
Dye's
all on
got.
me, Judge.
Well,
I'm
it's
not the
okay.
only one.
Magistrate Dye's got a couple, he says he's got some things that he thinks we need to consider. Let's do it. We can amend and change an ordinance as easy as we can, passing one. But right now, I feel like there's been a shot that's been put over our bow, and we're foolish to let them take another shot at us. Okay, let's move into a defensive position here and This is a ordinance that has already been approved by the Division of Water, so it's not a poor ordinance to begin with. I don't want people to think we put something together here that's not solid. It's just that individuals on our board have perspectives that they'd like to alter this, tilt it one way or another. So that's okay, we can consider that, but let's just do it at next month or in October. You know, there's no harm done. So did we have a second?
Yes.
To what? please?
Withdraw your,
Withdraw your recommendations?
Yes,
that you were just
I
making?
withdrew my,
The two recommendations you started to make?
I withdrew the recommendations on the extra page that I put out. So,
so are you going to have Squire Eldridge make a motion now?
what was your motion again?
My motion was just as council asked, that we would only have the changes that Ms. Raines put in there.
Second.
Judge, can you vote first on what's on the floor? Which is to withdraw yours. You have a first and a second.
Oh, okay, we're going to, well, I don't know, so I have to, if I withdraw it after first and second, do we have to vote?
Just do it for safety's sake.
My motion I made earlier had a second. Do we have to vote on that, or can I just withdraw it without a vote?
I think you can withdraw your motion if the person that seconded it withdraws it.
You withdraw?
Yes,
All
sir.
right, well,
I
let's
withdraw.
All right, and so we'll go back. The motion now is that we accept this document as presented. It had one minor change from the first reading, and
Second.
go forward. That was motion made and seconded, all right? All in favor, please say aye.
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 Opposed?
No,
Okay. Motion passes 7-1.
Your original three items are no longer.
Yeah, scratch
Okay.
that. Okay. Okay,
Did you want to have a public hearing? Did you want to open it up to public comment?
You have to have a public.
good idea, okay. We just took a vote on something that was supposed to be a public hearing. So, is there anyone here who likes to speak to the stormwater? Okay.
It appears that we do.
You mean to open this back up?
My name's William Douglas, 4631 Heritage Manor, Crestwood, Kentucky. As you guys have appointed me on the Stormwater Management Board and also on the Planning and Zoning Board. I just have one clarification, and this is for Mr. Carter. I know this was a minor change that was recommended by the Division of Water, but there was a long excerpt put in there for projects that disturb less than 1 acre that are part of a larger common plan of development plan. Is that pretty substance for a second reading? I mean, it's not like changing a period or, I mean, now we're adding something more to the ordinance. So I just want to make sure there's no,
I think that's my decision, and I say it's not substantive.
okay.
Let me help clarify. It's an inconsistency in the ordinance is what that is. If you look on page 1, where we say whereas,
Right. I
it's
see
there.
it's listed on that.
And so we're saying it here, and then when we say applicable back here, we were inconsistent.
Okay.
And it's just a consistency thing.
That's a clarification.
Okay.
Thank you. I'm for this. I think it's a great thing, and I do understand some of your concerns. But I know I've been doing research from other counties that have post stormwater construction, and they're already in existence of it, and they're pretty well as clarified as what we have here. So I think it was a good job that was done on it.
Right.
Thank you.
Okay, well, right, that, we're not trying to reinvent the wheel,
No,
but,
you're just trying to,
but we can
update.
fine tune it to our community as well.
thank you.
Yes, sir.
I'd like to hear Mr. Carter's answer. Is it a substantive change or not, in your opinion?
I don't think he needs to give an opinion because he doesn't, he's not called on me for an opinion here today on that. Next item on the agenda has to do with litter abatement, and we'll get Becky Zoklin here.
Thank you, Judge.
Gentlemen, we're applying for this grant to, which we receive every year from the state, to pick up roadside litter and keep our roadways clean. We get every year an average of $70,000. And in our county, we use it to pay nonprofit groups to go out and pick up the litter. They collect it for us, deliver it to the recycling center for an extra fee, and they also segregate recycling from the trash and contribute to the recycling, or recyclables. So I'm asking you to give the judge permission to sign this letter. What you see is the entire grant. It just requires his signature, and it's automatically given to us by the calendar year.
Judge, I make that motion that we allow you to sign this request.
Second.
Second.
I moved and seconded that I sign the litter abatement grant. Any discussion on that? Magistrate Eldridge?
Just a question, Ms. Auckland, did the city apply?
The city of, I don't know if they're applying this year. They did apply last year, for the current calendar year, and they did receive an award, to the best of my knowledge. I'm not sure how they are utilizing their funds.
It's my understanding if they don't apply, then we are eligible to do it in their roads as well.
That's correct.
Okay, thank you.
Any other discussion? All in favor, please say aye.
Aye.
Opposed? So moved. Thank you. Next item is Ms. Horn. This would be our image management system or agreement.
I'm presenting to you a proposal from XBE, which is the company that handles the majority of our copiers, printers, scanners in the county. This is to now move 3 more machines that were Konica Minolta to the XBE agreement. And the beauty of the XBE agreement is that it gives us the ability to pool all of our copies so that if one department goes over, another department goes under their quota, we don't pay anything for that month if in total we are under. The other thing this agreement does is takes that wide format printer scanner that is in planning and zoning that is quite old. It replaces that and puts that machine under the agreement as well. The incremental cost is $87 a month for everything.
Make the motion that you have the judge sign this agreement, and we move forward.
Second.
Motion made and seconded that I be allowed to sign this copy agreement. Is there any discussion about it? Hearing none, all in favor, please say aye.
Aye.
Opposed? So moved.
Judge? Ms. Stuber's ready to bring the awards for the paving projects. All except one, which was Rollington Road, and she needs to clarify that with the bidders, but we'll be awarding all the other ones except that one.
Come up here and tell us who our winners are today.
Okay. Everything looked to be good. So for Group 1, our low bidder was Ohio Valley Asphalt at $65,918.50. We take them one at a time or all together.
One, yeah, just
So,
take them all together.
okay. For Group 2, again, Ohio Valley Asphalt was the low bidder at $148,652. For Group 3, Riverside Paving was the low bidder at $200,677. Group 4, I need to clarify that they understood one point with the widening, so I'd like to hold off on that one. And Group 5, which is Greenhaven Dawkins, again, Ohio Valley Asphalt, $142,920.75. And the last was Group 6 with the soccer park. That's Hall Contracting, $76,088.05.
Right, is there a motion to accept those bids?
So moved.
Second.
Moved and seconded. Is there any discussion on them?
I have one. I think that, did you check to see if that was within our budget we had for those groups of roads? I think it was from our
Yes, it's
discussion
actually a
of road-
little under. I really didn't know where to put Rillington or Spear Lane, the other widening jobs, so it actually came in a little underestimate.
We're well within our paving budget.
All right, so we're not going to bring back forward that final one bid?
Yeah, I hope to bring that back on the 6th. Yes.
3 weeks, I think.
3 weeks, yeah.
Yes.
Magistrate Eldridge?
Is this in this season?
Yes, sir.
Yes.
So they're going to get this done before fall?
Yes.
Not necessarily. I mean, we hope they will, but it could extend over into next spring.
Okay, thank
Yeah.
you.
Yeah, they've all verbally committed to November 30th, but we'll see what the weather brings.
Any other questions? Hearing none, all in favor, please say aye.
Aye.
Opposed? So moved. Next item on the agenda has to do with a personnel appointment here, a building monitor at the Parks Department. This would be a Jacob Bailey, $7.25 an hour,
Did y'all make that
to
motion?
begin here in a couple of days.
So moved.
Okay, moved and seconded. Discussion. All in favor, please say aye.
Aye.
Opposed? So moved. Our second public comment time. Is there anybody that's come in that'd like to address the fiscal court here at this point? Seeing no one, I'll close public comment and see if magistrates have any final remarks they'd like to make today. Magistrate Logston?
Yes, sir. I met with the, out on Highway 22 with the engineer and the paving company. I guess it was yesterday. And they said they would be done with that within 2 weeks, but they're asking for 3 weeks just in case it rains again. So within 3 weeks, 22 should be finished right there, barring storms and rains. So,
I think we've heard that story before, Em.
yes, you have. Ask me again, I'll tell you the same.
All right, Magistrate Dye.
I'd like to thank the road department for getting the A-boom out in my district. There are several roads that need to be trimmed back, and it'll help certainly help the bus drivers, Magistrate Greenwell. Y'all like to keep those mirrors on,
We do.
and they did a great job, and it looks a little rough, but it'll come out next year.
All right, Magistrate Eldridge.
Nothing, sir?
Magistrate Sparks.
None, Judge.
Magistrate Logston, Magistrate Greenwell.
3 things, Judge. I enjoyed hearing today, read into the minutes, all the 5-4 decisions, 4-5 decisions, and that just kind of proves that we do get serious about our business, and they're not all 9-0 and 8-1s and all this kind of stuff. So that was good to see, and I really do think we should read the minutes. Second thing, school starts tomorrow. Everybody, please be careful. Watch for the kids. It's going to be different. There's a lot of them, and so just please be cautious. Third thing, thanks to Sheila and to Tina for trying to keep up with all of our motions and everything else. It's a tough job, and they do an excellent job.
Thank you. Magistrate Leslie.
Nothing today, sir.
Magistrate Tice.
I think Magistrate Greenwell covered it all. Well said. Thank you.
And Magistrate Likens.
Nothing today, Judge.
All right, Mr. Carter, you got anything? No? Cool. And let's see, did Magistrate Logston, did you forget to talk about your little fundraiser at Rotary or for Friday? Or
A fundraising going on for bourbon and wine. I don't like to do that, Judge, but
oh, it's legal.
on the stop.
It's legal. People voted for
Well, I
it.
understand, but Bourbon and Wine at South Oldham Rotary is going to have a, from 6:30 to 10:30, I believe, at the Udell Gardens. It's a Bourbon and Wine it's for charity. All the things go to different charities in Oldham County. But it's at Udell Gardens. There's food. There's all the bourbon tasting that you would like. It's $70 a ticket now. You can go to South Oldham Rotary's website to look it up if you want to order tickets, or you can go there and get your tickets at the place. But
Right, and in case someone doesn't know how it works, the different manufacturers, I guess, or distillers have their products there, and people are able to take a small sample of ones that they would like to try. And it's there's nothing raucous or wild about it. It's a very nice event at a very nice
classy.
location, and and it does raise money for South Oldham Rotary, which is very active in supporting events in our community and so forth. So good luck with your event. I'd also like to mention that we have made a change on our emergency management system. Those who were signed up for Code Red, please go to our website and now sign up for a new system called RAVE that it's available now to be signed up to. And I encourage everyone in our county to sign up for this weather warning system. And it's a really a good service, and you don't know what weather's coming up, so put your phone number on them and let them find you and give you an alert if a serious situation is on the horizon. So go to the Oldham County Fiscal Court website, just put our name in there, and our website, oldhamcountyky.gov, will pop up, and you'll find it right on the first page. It's real easy to do, so please go ahead and do it. With that, I think we had a, interesting and fun afternoon here, so we'll do it again in 3 weeks, I'm told, so not 2. There's an extra week popping up in the month, so anyway. Is there a motion to adjourn?
Second. Is that next week? Yeah, the local.
Yeah, that's a Thursday,
Yes.
Nice.
We got this thing at the golf house next week.
I can't do